doing. That worked. Okay. Welcome, everyone. My name is Anita Szigeti. I'm the president of LAMDA. We are, as you know, currently in the midst of a 7-part presentation series on consent and capacity board practice. We have a part 1, which is an introductory video to the practice that Shira and I did. That's available to you on my blog. Part 2 was about capacity with Danielle and Naomi. We've since had community treatment orders covered by Teo and Aaron Holder. There was a 4th part, somewhere in between there, we did involuntary admissions. And there were materials with all of these panels. So today is part 5. Today we are doing miscellaneous applications. So things that you don't see as commonly as treatment capacity challenges or community treatment orders. And we've all been assigned a particularly sort of esoteric bit. We are joined today by Dada, who you've heard from previously on CTOs. Today, she's going to talk with you right off the bat about challenging findings of incapacity with respect to the management of property or finances. Following her, you'll hear from Kelley Bryan, who's also a LAMDA member, and Kelley's going to talk with you about mandatory Form 17 hearings and Form 51 applications to the board to make orders, requests for orders in relation to those applications, which is kind of a weird little thing, but there's a lot to learn about that. Following Kelley, we're going to hear from Shira Brass, whom you know, and Shira is going to talk to you about the rest of the alphabet. Previously, we heard about Form A under the Healthcare Consent Act, challenging treatment and capacity findings. Today, we'll hear from Shira about Form B, C, D, and E. She got most of the alphabet. Applications to be appointed a representative to make treatment decisions for the person or to appoint a representative. Applications to assist with interpretations and applicability of prior capable wishes to current circumstances or to depart, permission to depart from those wishes. Following that, I will speak with you, and I was just regaling my colleagues about how I try to study up on my topic and found out that I didn't really understand it. So that'll be fun for you. You'll get 15 minutes of me explaining what a mess this is and how I don't understand it. But we're going to talk about informal patients and informal minors and children. And these applications, the Form F application, which I'm sure no one's ever seen, which is to challenge the decision of a substitute decision maker to place you in a hospital to be treated and admitted as an informal patient. I'd like to know how many of those applications anyone's ever received. But we're going to talk about that. And then Mercedes Perez, our cherished colleague, who I'm sure will not mind my saying for reasons incomprehensible to me, is still not a LAMDA member, but visits often and supports. And all that means is I have to send her emails I send to the LAMDA list separately, or BCC her, or get her the same information as a separate class of person. But Mercedes is going to come and tell us about her experience with Form G applications, which she's really expert at, and those are generally end of life, but they're applications to review a substitute decision maker's decision with respect to treatment, and she's really great too, Mercedes. So we've got a ton of brilliant women for you, and it's a no-man zone for the evening. With that, which is where I like to be, as everyone knows. So I'm going to shut off my camera, and I'm going to just spotlight Teo for everyone. And this is recorded for the registrant's benefit, who will receive a copy after the fact. So let me do that. Thank you, Teo. Welcome. And thank you so much for giving us your time again today.
Muted. Thanks a lot, Anita, and good evening, everyone. Just give me 1 second while I make this.
What's Fismo bar?
Okay.
Oh.
I'm going to ask everyone, please mute yourself. Okay. All right. So good evening, everybody. We have very limited time, so I'm going to jump right in. We've met before, so for those of you who know me, you know me. Those that don't. So I have 15 minutes, and I have to put on a timer. to talk about handling property applications before the Consent and Capacity Board. And of course, this is a very abridged version, just based on the timing that we have. So I'm going to be focusing on the legislative framework. I'll get into a few substantive issues just as time permits. So you are going to have to bear with me. I'm just going to be highlighting things as I go along. I do have a few cases that I've added to the material, which I'll send out. I'll send the material out later. I did not expand on them because there's just no time to talk. So as we all know, when it comes to incapacity to consent to in relation to property, we are guided by the Mental Health Act and the Healthcare Consent Act, but the Substitute Decisions Act is the main legal framework for property capacity matters. Sorry, I have something blocking me here. Okay, thank you. Section 6 of the Substitute Decision Act provides that a person is capable of managing their property if that person is able to understand the information relevant to a decision in the management of their property and able to appreciate the reasonable foreseeable consequences of a decision or lack of decision. Section 2 of the SDA provides that there's a presumption that everyone above the age of 18 is capable of managing their property. It's only where there are reasonable grounds to believe that a person is incapable of managing their property that the Substitute Decision Act is engaged. Now, the test for capacity to manage property is similar to the test for capacity for treatment under Section 4 of the Healthcare Consent Act. I'm not going to go over that because most of us know that and we've gone over it a few times. Now, the focus of the test is on the ability to appreciate the consequences of the decision and not on actual appreciation. Just like is established in Swazi, a patient need not have an actual appreciation of the consequences of their decision as long as they have the ability to appreciate their consequences. And the Supreme Court of Canada emphasized that as long as a patient retains the ability to appreciate the consequences of their decision, they're free to decide that adverse effects of a proposed treatment outweigh its potential benefits. And you'll find that this applies to property matters as well. Notably, as appeals regarding capacity to treatment have confirmed that foreseeable consequences refer back to treatment, appeals regarding capacity to manage property have confirmed that foreseeable consequences relate back to property. So sometimes you get into a hearing and you're doing a treatment hearing and they bring in property issues. And it's really important to highlight, you know what, this hearing is not about incapacity to manage property, because sometimes it's almost the basis for which they want to make a finding of incapacity as it relates to something else. Like I said, I'm not going to go through the case law, but you will have it to look up yourself. Just like we have capacity to treatment, capacity depends on time. This is fully applicable to incapacity to manage property. The individual must be shown to not only be incapable at the time of the initial assessment, but must be shown to be incapable at the time of the hearing. And the onus is on the assessor. Sometimes the assessor is an individual assessor, independent assessor, and sometimes the person that's doing the assessment is a doctor from within the hospital. And these are cases that speak to the fact that capacity is time sensitive. It is time sensitive. Now, the finding of capacity under the Mental Health Act, and that's where Form 18s belong, which is the main thing I'm talking about tonight. Section 54 to 60 of the Mental Health Act provide the procedure around findings of capacity made towards patients who are being held in a psychiatric facility. Now, if the physician under Section 54(4), the Mental Health Act provides, if the physician determines that the patient is not capable of managing property, he or she shall issue a certificate of incapacity in the approved form, and the officer in charge must transmit that to the public guardian and trustee. That usually comes in the form of a Form 33. Now, Section 61 provides a patient in respect of whom a certificate of incapacity or notice of continuance has been issued may apply in the approved form to have the board review the issue of his or her capacity to manage property. Now, the emphasis being on patient, because this has actually been an issue that has been raised at the Superior Court in a number of cases. One of them I've put in the material for review. Section 1, subsection 1 of the Mental Health Act defines a patient as a person who is under observation, care, and treatment in a psychiatric facility. And I'll come back to this when we get to the case of Gelber. Section 60, subsection 3 of the Mental Health Act provides if an application is commenced under this section by a patient in respect of whom a notice of continuance has been issued, the application may continue to be dealt with by the board even after the patient is discharged from the psychiatric facility. And this has been a bone of contention in many board matters as well as appeals. In Gelber, the Superior Court held that procedural fairness, there was no procedural fairness if the individual had asked to speak to a rights advisor before they were discharged, and then they were discharged and didn't have the opportunity to speak to a rights advisor. And when they came back to the hospital and wanted to file an application, and the board then said they didn't have jurisdiction, and the Superior Court said, no, that will be unfair because the reason why he didn't get rights advice and didn't file an application at the time was not because he didn't want to, it was because there was a glitch in the hospital system, and the hospital system's glitch cannot be held against the individual. So it's a very interesting case, a great case. Now, and like I said, this is almost for people that have ever done WIMAS. This is what this is like. It is as dry as anything, but you're just going to bear with me. And hopefully you like my voice. Now, as per Section 57(1) of the Mental Health Act, in event that a certificate of incapacity has been issued with respect to a patient, the attending physician must examine the patient within 21 days before discharge from the psychiatric facility to determine whether the patient is incapable of managing property. So it's your responsibility, if you're handling these matters, to actually check the dates and ensure that this examination happened within 21 days. The board has held on occasion that where the 21 days has expired, then there is a need for a new examination. So you need to keep abreast of that. In the event that the attending physician determines the patient not capable of managing property, they must issue a notice of continuance in the approved form, and that's the Form 24. And the officer in charge has to transmit that notice to the guardian, public guardian and trustee. When a patient in respect of whom a certificate of continuance has been completed is discharged from the psychiatric facility, the officer in charge must still transmit the notice of discharge to the public guardian and trustee. So the public guardian and trustee must be made aware of the finding of incapacity, the notice of continuation, and the fact that the person is actually discharged from the hospital. When a patient in respect of whom a certificate of continuation has been completed is discharged from the psychiatric facility, the officer in charge must, sorry, I think that's a repetition, must transmit it to the public guardian and trustee. Okay. Now, a notice of continuance cannot be issued to an individual who was previously a psychiatric patient when the certificate of incapacity was issued, but has since been discharged from psychiatry. So it's possible for an individual to come into psychiatry, be discharged from psychiatry, and be put into another unit. If they are discharged from psychiatry, even though they're within the facility, a notice of continuance cannot be issued if it was not issued when they were in psychiatry. And there's an unreported case. This topic is very well dealt with in Anita's book, like the guide. I call it the Bible of CCB. So please, you can go back into that and take a look at it. As per section 59, a physician who issues a certificate of incapacity to manage property or a certificate of continuance must promptly advise the patient of the facts and must promptly notify a rights advisor. So rights advice is essential. Rights advice must be prompt. I am going to skip the rest. The truth of the matter, well, this was an important point in the case of Gelber because the patient had asked for rights advice, had not received it until he was discharged. He was discharged without receiving it, and the Court of Appeal, the Superior Court found that was procedurally unfair. I'm gonna take the few minutes I have left to talk about procedural issues. Substantive issues, I mean. So, number one, it's very important for us to note that in property matters, corroboration is essential, just like in any other CCB matter. And Recouch held, sometimes I don't know if I say that, whether it's coach or couch, but anyways, any procedure by which a person's legal status can be altered, which is the inevitable result of a finding of mental incapacity, must be cloaked with appropriate safeguards and capable of withstanding vigorous reviews. And one of those safeguards is that there must be meticulous records. There have to be records to show, what the doctor is relying on. Sometimes we have matters, people come in and the doctor really doesn't have any evidence whatsoever that relates to the finances. They have not asked the questions. They've not tried to find out if there's been any debt, any mismanagement, any exploitation. Those are some of the things that you have to look into. And that's where client interviews are very important. It's really important that you do have a client interview. Ask your client, what do they own? Let's start from there. Like, what are your assets? What is your income? What is your understanding of your income? Do you know, like, if you get a house, do you know what to do? Yes, the person says, yes, I know I have to pay rent. I know I have to get groceries. Oh, well, but they say you're not eating. Well, I know how to get to the grocery store and I know how to spend my money. Did the doctor, were there any, did they do any mathematical questions with this individual? Any addition and subtraction? Those are the things that you're looking for. Has this person been paying their bills consistently? Is this just the fact that their mother or father hates the fact that they're using the credit card the way they're using it? What is the evidence that's supporting what the doctor is saying at this time? I'm gonna jump from there to the right to be foolish. Something that comes up a lot in property cases is people relying on what they consider, they call it the test, but it's the best interest of the individual. Well, we think it's in the best interest that they don't spend money like that. How a person spends their money is none of your business if they're capable. If they are incapable, yes, then we're talking to the PGT. But if they are capable, they can actually decide what they want to do. I had a matter where the doctor said my client was investing money in a specific business and it was a scam. And I was like, well, have you researched it? How do you know it's a scam? And it's funny because it's a business that I personally run myself. So in my head, I'm like, really now? And of course it was overturned because they were like, the fact that she is not successful in business does not make her incapable. So, and if she decides she wants to invest her money, a lot of capable people invest their money and lose it. And that was one of the things that I raised in that particular hearing. The court held in AA that AA was capable of managing her property. She simply chose not to, and it was within her rights to do so. So once again, the board was very clear that it's not a best interest test. Something that has also come up in quite a number of cases that I've done is the fact that you have to remind the board that mental capacity exists if the person is able to carry out her decisions or his decisions with the help of others. And this is, there's a lot of cases on this point, but that was exactly what Recouch said. The size of the estate, these are some of the substantial issues. What is the size of the estate? If you're representing an individual that's on ODSP, all she has to do is it's just $1,200, and ODSP pays her rent directly. So she's paying $600 directly. All she really has to manage is $400. The board looks into the size of the estate. It is relevant in the determination of whether an individual is capable or not. In Khan versus St. Thomas, the court reversed the board's confirmation that the appellant was not capable of managing her property. The court concluded that the appellant's liberty to manage her very little income had been taken away solely on the basis of her refusal to investigate the possibility that she might have a more substantial estate. So there are quite a number of cases. Like I said, there's 15 minutes. I'm trying to stay within time. I have very few minutes left. Now, whether a person benefits from medication or whether they're spending their money on weed or drugs is not a relevant consideration unless the individual is incapable. The question is, does this person have the ability to appreciate how to manage their financial property or their finances? It's cases where the doctor has been concerned about, that's in REWS, the doctor was concerned that the individual was using the money to buy alcohol. And the board said, well, that's none of your business. If they're not capable, that's different. But if they're capable, how they spend their money is their business. I'm just paraphrasing. Finally, last two slides I have, incapacity findings by assessors. There's another route by which an individual may be subject to the public guardian and trustee. And this is under section 16 of the SDA. It says a person may request an assessor to perform an assessment of another person's capacity for determining whether the PGT should become a statutory guardian of property. What we need to know is this is a voluntary process. The assessor actually has to ask the individual if they want to go through the assessment. If the individual declines, they cannot do the assessment if there is no consent. I cannot end this without talking about Kelley's matter. Assessors are usually the respondents in CCB matters. Recently, we've had the PGT seeking to be added as a party to CCB matters that involve Section 16 assessments. And in the case of PPV Ashley Oliver, the court for the first time ruled that it was procedurally unfair for the PGT to be added as a party, as among other reasons, the PGT had carried most of the case and the PGT was not waiving its right to utilize Section 27.3.1 to relitigate capacity if the court deemed that the patient was incapable. Interestingly, I had a similar matter that was actually decided on the first instance case. Literally, the member said, I'm deciding this case is literally on all fours with PP. And it went on appeal, and the judge found that it was not procedurally unfair to add the PGT. And I decided I'm not appealing this matter. Let's have the two of them in conflict for the time being. When we have the third one, I think we should think of going to the Court of Appeal. I want to thank everybody for listening to me this evening. Sorry if I've been going on a speed train. I hope you have been able to glean a little bit from what I've shared tonight. Thank you all so much for listening.
Hang on. Let me just switch between parties. I got to figure out how to, oh, there you go. Okay. I'm going to, couple of things. It's Rekoch. I'm
Okay.
very glad about the Gelber decision. Just want to say lately I've been complaining on our list about how we had a nice body of pro-client jurisprudence earlier and how the constitution of the board and other factors watered a lot of that away. So what the court did in Gelber was the law at the board for like 20 years. And so if you didn't get rights advice before you were discharged, when you came back in the next time, you would simply be able to have your hearing in relation to that mental health assessment of incapacity. And then in like the last 10 years, the board just started saying, we don't have jurisdiction. If they didn't apply, we don't care why they didn't apply. And the board has a problem appreciating that matters of procedural fairness cloak it with the ability to rectify those instances of unfairness. So when the Consent and Capacity Board chooses not to inquire further, but stick to the black letter four corners of the legislation, that always harms the client. And they're very reluctant to roll up their sleeves and inquire into issues of procedure. But it's obvious that if the reason you didn't make the application before you were discharged is you were prohibited from doing that, then you clearly should have that right upon readmission. So I'm glad that the court had some sense, and that's great work. And good to know about Kelley's and your case being in conflict. I think I saw that. That's too bad. Okay, Kelley, you want to come back on? Thank you so much, Tayo. I know it was a lot of information.
You're welcome.
I think we'll pick up steam when we get to me because I have a lot less to say. So welcome to Kelley. And just to tell everyone, no, don't keep turning off your camera. I'm trying to introduce you. Come back.
I was trying to unmute, press the
Oh,
wrong
okay,
button.
there you
Sorry,
go.
everyone.
I'm gonna spotlight you. Kelley, together with the student at their firm, Caitlin McNair, has written a very comprehensive paper together with a lot of research into data about the cases that she's included in her chapter about these Form 51 orders that no one's really looked to see what the Consent and Capacity Board is doing in terms of what orders it's prepared to grant to long-term detainees. So if you do get our book, you'll have the benefit of a really wonderful chapter by Kelley on this issue. So welcome, Kelley, Form 17s and 51s. Thank you for being here. I know you have a lot of kids, a lot of pressure, so we're glad you're here. And I'll go forward.
Thanks very much. Now, Anita, I have a question for you before you leave. I don't think I can show copies of my chapter yet. Is that right?
I mean, we'll ask people not to like screen and grab and publish, like, so we don't want to see your paper on Twitter. But it's
just some of the images. That's all I wanted to share.
It's pre-publication, but you're absolutely welcome to share in this cone of silence. It's good advertising for our book. So
all right, good.
So for that reason, I'm prepared to breach LexisNexis copyright. It's fine. I actually just filed one of my papers from the book like as authority in a hearing that's ongoing. Like if we need the information, we need the information. So go ahead. I've given you the ability to share your screen anyway.
Okay, perfect. Okay, well, I'll share my screen in a minute when we get to some of the statistics. Thank you, Anita, and hi, everyone. Very happy to be here. So my topic is Form 17s and Form 51 applications under the board. Most of you probably know that these are coming up to 10 years now, but in the lifespan of the board and the types of applications we see before it, still relatively new provisions. They came through amendments in 2015 that followed a Court of Appeal case called PS in Ontario that was litigated by my colleague Mercedes, who will be with you later, in 2014. And in that case, the Court of Appeal found that provisions of the Mental Health Act relating to involuntary detention of long-term detainees, which they defined as people who were detained at a civil psychiatric facility for 6 months or longer, was unconstitutional because in that situation, the board only has, and if you've done the Form 16 applications and you practice in this area, you know, the board really has a stark choice to confirm or to rescind a certificate of involuntary admission. And the Court of Appeal said, well, that's unfair when it comes to long-term detainees, because in that scenario, the board should have some power to look not only at whether they should be detained or not, yes or no, but to look at if they're going to be detained, what should be the circumstances of their detention. So for those of you that do Ontario Review Board work, you'll be very familiar with that concept. We're looking at, since someone is detained, what should be the outer limits of their liberty package, and is there anything that we can do better? So that was the thrust of the Court of Appeal decision. In 2015, these amendments came in, and they essentially say for anyone who's continuously detained for 6 months or longer, they're not on a Form 4, but on a Form 4A, it's called, and there's a mandatory deemed application on the first Form A and every fourth one thereafter. So that's under Section 39 sub 4 of the Mental Health Act. So nobody has to apply. It's not an application the same way a Form 16 is an application. It's a deemed mandatory application. The patient is deemed to have applied whenever that form is issued. Anyone who's on a certificate of continuation, a Form 4A, can still apply to the board if they want to at any time during their detention. They can still file a Form 16, or someone on their behalf may do that. And Anita and I had a case together where a parent was applying on behalf of their adult child who was in hospital. Many of these cases relate to, at least in my experience, relate to patients who have developmental disabilities or other intellectual disabilities. It's a very sad situation where people are detained in hospital for months or years because there's nowhere else for them to live. And there's no housing for them in the community. Their family can't have them for one reason or another. Or in the case that Anita and I had, the doctors didn't want the family to have the person with them, living with them. So they're tough applications. And I think it's important to have that deemed application, because you're not relying on the patient interacting with a rights advisor and making a positive statement that they want to apply to the board. Some patients, and especially the patient population that's often caught under the Form 17 applications, are those who don't have or may not have that ability to give express instructions to a rights advisor to file an application to the board. All right, so anyone then who is having a Form 17 hearing or a Form 16 relating to a certificate of continuation can file, the patient can file a responding application, which is the Form 51. And that's in section 41.1. And I'll just share my screen. Oh, I'm disabled on screen sharing.
Okay, I'll try
And,
and fix that. I will fix that for you. I will try.
Thanks.
Oh, I don't know how to fix it. Hang on. I'm gonna unspotlight you. And then there's so many things I have to do to you. Hold on. Why would you be disabled?
It's telling me host
Is she
has
a co-host?
disabled.
If she's a co-host, she should be enabled.
Oh, sorry. Forgot to make you co-host. Try it again.
There we go. Perfect. Thank you. Okay, so this is the Form 51. It's a fillable form, and handy just to have. This is all in the Act, but these are the types of orders that can be applied for. And so when the amendments were made to the Act in 2015, I guess one option for the legislature would have been people can apply for any order that they think might be appropriate. But no, that's not what the legislature did. They said there are 5 specific types of orders by statute that the patient can apply for. So you have to fit, if you're going to make this type of application, you have to fit your request into one of these 5 categories. So a transfer to a different facility, a leave of absence, but that has to be on the advice of a physician. That's a prerequisite for getting that order. Different security levels or privileges within or outside the facility. Supervised or unsupervised access to the community, or vocational interpretation or rehabilitative services. And some of the cases under this last category have included cultural services. So for Indigenous clients or people with other special cultural needs, people have been able to lump in some orders under that category, vocational or rehabilitative. So these are the types of orders that can be applied for. So as patient counsel, you need to file this on your client's behalf. And it's important to keep in mind that the orders are discretionary. So the board will, first of all, the onus is on the applicant. So here the onus is on the patient and their counsel to establish, to convince the board that one of these orders are necessary. And because it's discretionary, the board will be asking you, well, is it really necessary for this order to be made? Hospitals will typically resist these orders because they don't like being ordered to do something, understandably. You might often face the response that, well, you know, we can do these things voluntarily if and when the patient is ready for them, and they're not ready for any of these things, so don't order us to do it, but don't worry, we'll do it when we're ready to do it. So that might be a response that you receive. If the response from the physician is, yeah, we'll think about it, we're going to work on that, the board might say, well, it's not necessary to make the order. I've got evidence and I've got a response from the physician that they're doing their best and they'll think about it. In other cases, the board may make an order, but leave the implementation subject to the discretion of the doctor. So similar to what we see in the review board context. Or they might make the order, but say it can be withheld. So for example, this person gets privileges, they get to go out on the grounds, but it can be withheld based on their behavior on any particular date. So, I only have 5 minutes left. So I'm going to share my screen again. So these are the figures that I was talking about from the chapter. So let me show you some of the statistics. So myself and my student, we asked the board, we filed an FOI request asking the board for statistics on Form 17 and Form 51 hearings. And interestingly enough, that's not an FOI issue. They sent us back the $5 check that we had to file for the FOI, and they said you can get that information anytime without an FOI request. So good to know. And we should ask for statistics for these hearings more often, for all the hearings. Interesting. So these are, first of all, Form 17 applications comprise somewhere between 1.5% and 2% of the applications that the board hears. So there's less than 200 of them a year. And it's hard to know whether it's the same patients. It may not be 200 patients, might be repeat patients. And then these are the outcomes that we saw from the cases that we looked at. Sorry, I'll make that bigger for everyone. So for Form 17's, involuntary detention was confirmed 76% of the time, rescinded only 2% of the time. And sometimes 16% there was a Form 5. So that's Form 17s. Now Form 51s. If you look at this figure on the left, 21% dismissed, 17% were withdrawn. And I've probably had a few cases in that withdrawn category. So sometimes what you file your Form 51, and then before the hearing, you're able to reach some resolution, or the doctor agrees to do certain things. And so on that basis, you end up withdrawing the application. So withdrawn before the hearing or withdrawn at the hearing, I guess together, those make up about a third. In 30% of the cases, orders were declined. So they considered it, but they declined to make any orders. Only 14% of the cases were any orders made. And then among the orders made, if you look over to this figure on the right, the bulk of them related to community access or changes in security levels or privileges. Transfers are quite rare. Vocational services quite rare, and leave of absence the rarest, which makes sense because you need a physician's recommendation for that. And you would think if you've got a physician's recommendation, why do you need an order from the board in most cases? So I guess the upshot of these statistics is that if we've got 14% of Form 51 applications being successful, why is that? And when we looked at the cases, we saw a few reasons why that might be. One reason is that I think sometimes people are just acting on instructions. So your client might express a wish that they want something. And so you file a Form 51 application, but you've really got no evidence to support it. You don't have a case to make for it. And so a number of the cases that we looked at really amounted to not much more than counsel putting forward a wish on behalf of their client, rather than having evidence that the board can rely on to make the order. So it's hard on our side as patient counsel, it's hard to get that evidence. That's always a challenge when we have to say you want to show that somebody should have community access. You could do that through cross-examination of their attending physician. But it would be better if you could get it to have some other evidence or witnesses on your side. Sorry, there goes my timer up. It would be helpful to have some witnesses on your side if you can garner that to really put forward more of a robust case. And that's not that easy for us. So that's one side of it. The other side of it is the board, the hospital will resist the orders, and the board they tend to take a conservative approach. If they can not make an order and justify that, it seems to be that's the approach that they take, because they don't want to be seen as, I think my view is board members on the CCB might not be as confident making orders that seemingly encroach on clinical decisions and administrative decisions. It's not as familiar to them as it might be to members of the review boards who arguably do that more often.
So I popped on here to plug another chapter in our book, but it's related, because you and I haven't even had this conversation, but there is another chapter in this CAMHL, the Canadian Anthology on Mental Health and the Law, that I co-wrote with Dina Bonet from CLOC from 720 Bay that compares and contrasts this idea of duty to inquire, or the inquisitorial role of the Forensic Mental Health Tribunal, the Ontario Review Board, versus the Consent and Capacity Board. And what's so interesting is these Form 51 orders are where these two tribunals sort of collide with overlapping potential order making powers, except that. So all these things that you saw in the form that Kelley brought up about the different kinds of orders that may be made are orders, in effect, that the ORB has the power to make. However, the CCB, the Mental Health Act, took all that language and said, great, we're going to give the CCB the same powers, but yet didn't expressly give the CCB the inquisitorial duties that go along with it. So at the ORB, we don't have to make the case for these things. It's up to the board to inquire into whether it would be least restrictive to have certain of these, for example, passes, privileges, or where the person should be detained. And that's a fair way of doing it. It should really be the tribunal whose job it is to ensure that it's making the effectively charter compliant orders. There shouldn't be any onus on vulnerable detained patient applicants to gather, as Kelley says, the evidence for these various things. So the civil patients really got screwed there, because it's like a bad joke, right? Like we're giving them this illusion of certain options that they might get if they serve long enough as detained patients. But then we also gave them the job to prove why. And they can't really, even with counsel. So that's now 2 chapters in the book that's very important for you to read together. And then we're going to continue to build along those lines. We should rename this as part 5 of the CCB practice, promoting things that I want you to read. But these things are actually all, all joking aside, these things are pretty sophisticated. And if you just jump into representing a patient on one of these applications and you do nothing, I think you'll find that you get nothing. And Mercedes is with us. So Kelley, we actually have 3 speakers to somehow get through. Thank you so much. I'm gonna
My pleasure.
put Shira up. Try and stay with us. It'd be rude to leave because your partner's coming to speak to us. Shira, can you join me? Okay, great. I think I've let Mercedes in, which is cool. So Shira's here. Everybody already knows Shira in LAMDA, so I don't have to further introduce her. She's gonna do the alphabet soup of B, C's, D, and E's. And thank you, Shira, for making time for us. Go ahead.
Thank you so much, and thank you for being here and for the excellent presentation so far. As Anita said, I'm going to be going through the alphabet forms B, C, D, and E. And I know that we are short on time, so I will try my best to get through the material as quickly as possible. What is helpful is that actually a lot of the procedures and rules for a Form B and a Form C overlap. So I'll go through the application under a Form B and then just explain some of the differences between a Form B and a Form C. So that way we can keep our CPD on track this evening. So starting with a Form B. A Form B is an application to the board to appoint a representative under subsections 33(1), 51(1), or 66 sub 1 of the Healthcare and Consent Act. So what does that mean? What? Oh,
He was in the bathroom.
Adora, you need to mute yourself.
Yeah, I think they did. Sorry about that here.
It's fine. Okay, so what it is, this is an application by a person who has been found incapable to have a representative appointed. And this is for, depending on what it's for, if it's section 33(1), 51(1), or 66(1), is what the application is for a representative. So for section 33(1), that is if a person is found incapable for a proposed treatment then they can apply to the board for the appointment of a representative. For section 51.1, it's if a person is found incapable with respect to admission to a care facility, they can apply to the board for the appointment of a representative. And section 66.1 is if the person is found incapable with respect to personal assistance services, they can apply to the board for a representative. And how this works is if the person is 16 years or older and they are incapable with respect to either the proposed treatment, the admission to a care facility, or the personal assistance services, they can seek a hearing to have someone specific represented to be the decision maker. Now, this is specifically applicable if the incapable person does not have a guardian or a power of attorney for personal care. And in terms of the hearing, the people that would be there would be, of course, the applicant or the incapable person. The proposed representative, so the person sought by that incapable person to be their representative, as well, in terms of who we look for as substitute decision makers, section 20 sub 1 of the Healthcare and Consent Act details specific people that may be parties to the hearing, and that can be the incapable person's spouse or partner, or the parent or child, or a brother or sister, or another relative. As well, the person who proposed the treatment or the admission to the care facility or the personal assistance service would also be a party. So that can be the health practitioner or the doctor, the person responsible for the admissions to the care facility, or a staff at the provider's office who is responsible for personal assistance services, and any other person the board specifies. And then the board can authorize the representative to give or refuse consent on the incapable person's behalf with respect to either the proposed treatment or the admission to the care facility or the personal assistance services. Going on to the criteria for the appointment. The board would appoint an individual if the specific criteria are met. So first, this is if the incapable person does not object to the appointment, and if the representative consents to being appointed. And finally, this appointment must be in the person's best interests. And when looking at the powers of the board, they are able to put conditions on this appointment. So they can appoint a representative that's different from the individual named in the application. So different from the individual that the applicant sought to be appointed. They can also limit the duration of an appointment. So, for example, if this is something that is very time specific or time bound, they may limit the duration, or they can impose other conditions on the appointment or remove or suspend conditions that they've put on such an appointment previously. And this person would be made the representative. And this will last until the incapable person or the representative applies or requests for that to be terminated. Or, of course, we know that substitute decision makers have to be capable themselves of making decisions. So it would end if the SDM is not capable. As well, it would end if it's no longer in the incapable person's best interests, or if the incapable person has a guardian or a POA, where that person should be the individual making the decisions based on the hierarchy listed under Section 20, Sub 1 of the Healthcare and Consent Act. So that's a quick rundown of what a Form B is. And I'll give an even quicker rundown of what a Form C is. It's actually quite, so for a Form C, what it is a person applying to be appointed the representative for the incapable person. So to distinguish this, in terms of a Form B, that's an application by the incapable person to have a representative appointed, whereas a Form C application is an application by a proposed representative to be appointed. And it's the similar criteria, the same rules and same procedures apply. They also apply with respect to the proposed treatment or admission to a care facility or personal assistance services. So I'll be able to go through Form C quite quickly because it is in fact the procedures and the rules apply for both Form B and a Form C. So I will now move on to Form Ds. And a Form D is an application to the board for directions. And this can be an application by either the substitute decision maker, or whether if it's for a treatment, it could be an application for directions from a health practitioner. And it could be a substitute decision maker, or if it relates to admission to a care facility, then it could be an application by the person responsible for authorizing admissions to a care facility. Or with respect to personal assistance services, it can again be the substitute decision maker or a member of the service provider's office of the personal assistance service. And these types of applications come if the incapable person expressed a wish with respect to treatment or admission to a care facility or personal assistance services, but the wish is not clear, or it's not clear whether their prior capable wish actually applies to the current circumstances, or if the wish was expressed when the incapable person was capable, or if it's not clear, not known if the incapable person was actually 16 years or older at the time they expressed the wish. So these are some of the scenarios where a substitute decision maker or a treatment provider, care facility, or staff service provider may apply for directions to the board. And in terms of this, if it's the health practitioner or the person responsible for authorizing admissions or the service provider, they have to inform the substitute decision maker of their intention to seek directions. And at any of these hearings, the incapable person themselves would be a party, the substitute decision maker, the health practitioner who proposes a treatment, the person or if it's a care facility, person responsible for the admissions to the care facility, or the staff responsible for personal assistance services would all be parties to this hearing. And in terms of this is where, again, the wishes are not known or they need directions. So what they look at are first prior capable wishes as much as possible. So they look for the prior capable wishes of the currently incapable person. And if the wishes are not known, then the board is to look at and give directions that would be in accordance with the best interests of the person. And when we assess, so I'll go through some of the criteria for best interests. In looking at what the incapable person's best interests are, they look at the values and beliefs that the incapable person held when they were capable, and what they believe that person would do if they were still capable. And they also look for wishes expressed by the incapable person with respect to treatment or care facility or assistance services. And they also look at if the treatment or admission or service is likely to improve the incapable person's condition or prevent them from deteriorating or reduce the extent to which they would deteriorate. And they look at if the person's condition is likely to improve, remain the same, or get worse without the treatment. And does the benefit of this treatment, admission, or service outweigh the risk of harm? And they look at if there's a less restrictive treatment that could be as beneficial as what is being proposed. And I'm keeping on using the term treatment. It's just a mouthful to say the treatment or the admission to a care facility or personal assistance services, but it's respectively depends on what the application is for. So if I'm saying treatment now, bear in mind that it depends on what the specific application is, and it could relate to medical treatment, admission to a care facility, or personal assistance services. And if we're dealing specifically with the admission to, or sorry, for personal assistance services rather, when we're dealing with personal assistance services, the person cannot give consent on the recipient's behalf to be confined or have monitoring devices or restraints unless if it's essential to prevent bodily harm. And as much as possible, the goal is to encourage the recipient or the incapable person to participate in the decision-making where possible. So we do still try and involve the incapable person as much as possible when we're dealing with Form Ds. And I'll move on to Form Es. And these relate to applications to depart from the prior capable wishes of someone who is now incapable. And that relates to an application by a substitute decision maker to depart from wishes for a proposed treatment or with respect to admission to a care facility or personal assistance services. And in terms of these applications, what they look at are, of course, the wishes that they had expressed when they were capable and after the age of 16. And the parties to a hearing or the applicants can either be the substitute decision maker seeking permission or the healthcare practitioner proposing treatment, person responsible for the admissions, or service provider to obtain permission for the substitute decision maker to consent to what is being proposed. And for these applications, the criteria for the permission to depart from the prior capable wishes are specifically if the board is satisfied that the person who's incapable, if capable, would probably give consent now because the result of the treatment or admission to the care facility or services the results of that would be significantly better than what was anticipated in the comparable circumstances at the time the wish was originally expressed. So you look at differences in what the conditions are now, what the circumstances are now, and if the anticipated results now are much better than what was present at the time that the individual expressed their capable wishes. So I tried to go relatively quickly through this material, and because of the time, we're short on time, so that will complete my presentation on these 4 applications. And now I'll hand the floor back to Anita.
Good job. Let me just say one thing about the Form Bs that you talked about, Shira. The test about the appointment has to be in the best interest of the incapable person. I think it's the same test with Form Cs. The big battle in the jurisprudence historically has been that the board at one point interpreted that test by looking at the content of the decision. Sorry, I've been so sick. The content of the decision. So they would ask the proposed decision maker, would you consent to this treatment, or would you refuse the treatment if we made you the representative? And that's not how the legislation is intended to be interpreted. It shouldn't depend on the content of the decision. It should depend on whether or not it's the appointment that's in the best interest of the individual. That's how the legislation is framed. And so sometimes the contest is a family member wishes to displace the public guardian and trustee. So, a cousin is prepared to step up and make decisions for someone rather than having the government make that decision. And perhaps there's something about that that's in the best interest of the individual without trying to figure out what they're going to do. Because how are they supposed to know what decision they would make about the treatment when they have not been the substitute decision maker? They haven't even received the information they need to make that decision. So it's particularly unfair to turn these hearings into, we're not going to appoint you if you're going to refuse the treatment the doctor wants to give you. So there's a lot of interesting wrinkles that go into hearings of these applications when they do happen. The other time you'll see Form C applications often is when a family member has been passed over altogether as substitute decision maker because the doctors decided they're not capable to make the decision as a substitute themselves. And the doctor just, skipped over a husband or a mother and went to the public guardian or went to another family member lower on the rank. Then the person who was passed over as allegedly incapable, they cannot challenge that incapacity finding because it's not formal and this is not their doctor, but they might apply to the board asking to be appointed the representative to make these decisions. So there's a lot of weird manipulation of these applications in practice for unintended purposes. Thank you very much, Shira. It was a really good presentation. Now, Mercedes is with us, and in between Shira and Mercedes, I was supposed to talk. I'm going to take a few minutes. Can I take just like less than 5 minutes, Mercedes, to talk about something and then hand it over to you on the Form G? I'm sorry. Welcome. We're so glad to see you at LAMDA. Nobody here knows that you're not a LAMDA member. Thank you for coming. You can stay on camera if you want or not. Okay. So I'm going to be very quick in talking with those of you so I can hand it over to Mercedes, who's going to talk about Form Gs. I was going to talk to you about something called a Form F. We don't have to talk about it for very long because I'm not sure anyone's ever seen a Form F application before, and I bet you don't know what it is. So I'll just tell you, a Form F application is to be brought by an informal patient who is over 16 years of age and is objecting to this idea of being admitted to hospital for purposes of treatment. And they want to ask the board to look at whether or not the place of treatment that they're receiving pursuant to substitute consent is the right place of treatment for them. And the board can start asking all kinds of questions like, the place where the substitute agrees to have them treated, does it have what they need? Are there other places that could accommodate them that would provide better services? Should they be discharged? Is there some problem with the decision making of the substitute? So we don't have the time or the ability to drill down on the complexities of informal patients. But in just a few minutes, I flag for you that you probably don't know what an informal patient is. And you can be a regular practitioner before the Consent and Capacity Board and never see a matter involving an informal patient. But in fact, there are three kinds of psychiatric patients. We tend to think of voluntary patient or involuntary patient. You're either there because you want to be there or somebody else is forcing you to be there or the doctor has certified you. Well, there's a third category of patient, and that patient is the informal patient. And our Mental Health Act doesn't bother to parse apart voluntary versus informal patients often enough. So, for example, if you look at a Form 5, a doctor can decide to change your status from involuntary to that of a voluntary or an informal patient, but they don't have to specify which one. I think we all understand what a voluntary patient is. An informal patient is someone who is admitted for purposes of treatment to a psychiatric facility pursuant to substitute consent. And if you're over the age of 16, you can only be admitted as an informal patient if you do not object to being treated in the hospital pursuant to substitute consent. If you do object, you can still be held as an informal patient only if your substitute decision maker is a court-appointed guardian and possibly an attorney for personal care. I have to look at that. And if that's the case, if you've got a court-appointed guardian who's forcing you to be admitted to hospital for treatment, then you can bring this Form F if you object. Otherwise, there are no other applications, because if you don't object, what are you going to apply that? The problem is there's not really a procedural framework around forcing someone to advise you that you're an informal patient and what you can do about it. And finally, there's a whole category of children between the ages of 12 and 16 who are being held as informal minors. We can certify as involuntary patients children of any age. And in fact, I've done hearings for children as young as 11, I think was my youngest one. We might have seen an 8-year-old, actually. I think we saw an 8-year-old. I had an 8-year-old and an 11-year-old. But we tend not to want to do that, obviously, put them on involuntary forms of committal. So between 12 and 16, informal minors are kids who are admitted for purposes of treatment to a psychiatric facility pursuant to substitute consent. They don't have to agree, like people over 16 must not object to be informal patients. Kids can object if they want, and whether they object or not, they get mandatory reviews of their informal status. And that's the one place in all of civil mental health law in Ontario where, when the board receives one of those applications that you can apply once every 3 months, have a mandatory hearing every 6 months on an informal minor application, the board can decide that you should be discharged. In every other case that we see in mental health law, the board just decides whether your involuntary status will be upheld or if it'll be rescinded, in which case you're a voluntary patient. But a forced order discharge, you can only see when you're an informal minor. They can also order that the place that you're being detained should change. You should be held somewhere else. So I have a lot of stories about this, but that's for another time. I just flag for you, if you get a case involving an informal patient, call somebody for help, look through our Consent and Capacity Board guide, and don't sort of try this without adult supervision. Mercedes, that's all I have to say. You're on with Form Gs, which are really horrible and underpaid. Good luck.
Well, thanks for inviting me to participate in this CPD. I am going to be talking about Form G applications, and specifically, I'm going to focus on Form G applications that arise in the treatment context. A Form G essentially arises when there's a dispute between a substitute decision maker and a physician who has proposed a treatment. Form Gs can also arise under Section 54 of the Healthcare Consent Act, and that's when there's a dispute between the substitute decision maker and the person who is proposing admission to a care facility, typically a long-term care home. Form Gs also arise under Section 69 of the Healthcare Consent Act, again, when there's a dispute between a substitute decision maker and the person who is proposing what is known as collectively as a personal assistance service. But we typically see Form Gs most often in the context of treatment decision making. So I'm just going to focus on that. And just taking a step back, I'm sure everyone in this group is aware that a treatment cannot be administered unless there is not only informed consent, but capable consent. So in other words, if a physician proposes a treatment of some sort, a medication or a surgical procedure or whatever it is, if the patient is capable, then the patient will accept or refuse the proposed treatment. If the person is incapable, then of course, as all of you know, the treatment decision can only be made by a substitute decision maker. And substitute decision makers, when they are necessary, they can't just make whatever decision they think is best based on, you know, whatever subjective or objective criteria they think are important. They are required, as some of the previous speakers explained, they are required to make a decision in keeping with Section 21 of the Healthcare Consent Act. So these are the principles for substitute decision making, or the principles for giving or refusing consent. And again, I won't go through every single principle because it's already been explained, but essentially, in a nutshell, substitute decision makers must make treatment decisions first in keeping with any prior capable wish that the incapable person made while capable. So sometimes you see those types of wishes expressed in powers of attorney for personal care, although they don't have to be written down at all. And if there is no prior capable wish, which is often the case, then the substitute decision maker has to make decisions in keeping with the quote unquote best interests of the patient. And again, the best interests are defined in the legislation in Section 21 sub 2. And best interests require us to look at the values and beliefs of the incapable person, and then to look at what impact the treatment is expected to have. Is it expected to improve the person's condition? Does it offer benefits? And I'm just summarizing here for the sake of brevity, but essentially there's a weighing in that's required to determine best interests, where you look at risks and benefits, you look at the person's condition, you look at whether the treatment will improve their condition, will stop their condition from deteriorating, whether the benefits outweigh the risks, and whether there's a less intrusive or less restrictive option available. So that's the job of the substitute decision maker. Sometimes a doctor will propose a treatment, and that the doctor obviously believes is in the best interests of the incapable person, and the incapable person's substitute decision maker disagrees. And usually it's a refusal. It's the substitute decision maker saying, no, I've heard all the information you've given me. I don't think that is in the best interests of the incapable person. And Form Gs arise when SDMs are family members. So it's usually a family member, a close family member, making a decision for a loved one. If the SDM refuses the treatment, and if the doctor feels very strongly that that is not a decision in the incapable person's best interest, then the remedy, the legal recourse available to the doctor is to bring a Form G application to the Consent and Capacity Board. And the Consent and Capacity Board will determine the issue. Form Gs typically arise, well, they often arise in the context of a physician proposal to withdraw life support. So often they arise in the context of an incapable person who is incapable because they're in a coma. They've been put on life support. They've been on life support for a certain amount of time, and the physician decides that it's futile to continue with the life support, and that is actually in the person's best interest that the life support be removed and essentially that they be allowed to die. That's a very typical scenario for Form G treatment related applications. We also see these in the context of psychiatric treatment. The ones that I've seen have almost always invariably been around whether to administer antipsychotic medication to an incapable patient. But they arise in a whole host of different scenarios. I've done Form Gs in the context of dialysis, in the context of ECMO machines for a patient who was actually awake and cognizant. I've done them in the context of the antipsychotic medication. That's a very common one. So at the hearings itself, Form Gs tend to be quite complex. Form G treatment application hearings tend to be quite complex because often the medical information or the relevant medical evidence is quite complex. And they tend to be lengthy because at that point, there's usually, physicians tend to bring Form Gs when they feel that they've exhausted other options. They've tried to meet with the substitute decision maker, they've had meetings, they've had explanations, they've gotten written information. They feel very strongly that the SDM is not making the right decision, but equally on the other side, the SDM feels that accepting the treatment or consenting to the treatment that the doctor is proposing is not in their loved one's best interest. The board determines the issue. And so at a Form G application treatment, the board can basically make its own decision. The board can substitute its opinion for that of the substitute decision maker, and it can go further. It can order the substitute decision maker to make the treatment decision, either the one that was proposed by the doctor or some version of it within a certain period of time. And as you all probably also know, there is a hierarchy of substitute decision makers. When you don't have a power of attorney for personal care in play, Section 20 sets out who it is that is first in line to make a treatment decision for an incapable person. So at the top are adult children, or not necessarily adults, but children over the age of 16, as well as parents, spouses, siblings, etc. So if the board makes an order in a Form G application telling, Mr. X that he has to consent to the withdrawal of life support by a certain date, and Mr. X refuses, the board's order then would still apply typically to any subsequent substitute decision maker. So the next in line, if there's, for example, if it's a parent that refused, but there's a brother in the picture, that might still apply to them. If the substitute decision maker ends up being the public guardian and trustee, then the PGT, according to the legislation, is required to comply with the board order. All Form G applications start off with what is called a deemed Form A application, and a Form A application is, of course, an application to review whether the alleged incapable person is actually incapable. So that's that's Form Gs in a nutshell.
So
Often, maybe if I could just say a couple of other things. From experience, I've done a lot of Form G applications. They do tend to be very difficult for substitute decision makers to succeed at. It's possible, I think, there are different ways of challenging the doctor's opinion. One of them, which I've been successful in, is looking at what information was actually given to the substitute decision maker, and if that's incomplete in some way, that might lead to success. Another way is to look at the values and beliefs of the incapable person if you're dealing with an adult. So, for example, in the Friedberg case, the woman was the alleged incapable person, an elderly woman, was an Orthodox Jew, and we were able to show that the so-called prior capable wish in her power of attorney for personal care was something that she wouldn't have signed on to had she understood it. It required that no life support measures be used, or artificial or heroic life support measures be used. She was in a coma at the time. But overall, I find that it's a pretty uphill battle with Form Gs. Not impossible, but not so easy.
yeah, I think we summed that up with the board's ready to unplug most people, like at the first time.
Well, I think that yeah.
Yeah.
I mean, there are the issues with the board itself, but I think Form Gs in particular, by the time a physician brings a Form G, they're pretty, they've probably got 2 or 3 or 4 other opinions backing them up. And it's hard for a substitute decision maker to battle that.
So all of these Form Gs are endlessly sad. Because usually there's warring family members. Some want to unplug grandma, some want to keep her going, but they also often relate to kids. They also often involve very seriously held religious beliefs. So, and most of them actually resolved by the person dying in the middle of the proceeding, because either the proceeding goes on long enough that the person will die regardless of being on life support, or there's a medical emergency at the center of it. So I've had a hearing like at 7 o'clock in the morning at a hospital when there was a car accident and Jehovah's Witness parents were refusing blood transfusion for a child involved in the accident. And in the middle of our hearing, that child died because they hadn't received that blood transfusion. So these things can be, very, very dramatic. I always find that one way or another, they're dramatic. And traumatic and difficult, should probably be held in person rather than on Zoom or by the phone. And the last thing is, there are no lawyers prepared to do Form G hearings, no lawyers with any sense right now, because during COVID, other than Mercedes, who has sense, but she and I talk about this a lot. During COVID, legal aid sensibly increased the tariff for Form G CCB hearings from 10 hours, which is the normal tariff for every hearing, to 25 hours. In my experience, properly going through these records, looking for prior capable wishes from the person's whole life can take closer to 75 or 100 hours of preparation. So going from 10 to 25 was marginally better, though nowhere near the kind of time you need to do it right. During COVID, legal aid also was prepared to give a legal aid certificate to substitute decision makers who are responding to these things. And then maybe about a year ago or so, they took all that away. So now you get paid 10 paltry hours, your $1,000, good luck to you, to deal with this mess. And everyone is upset and emotional and needs you. There will never be a more needy clientele, a more emotional, more complex, more difficult hearing. So if you were a Bay Street lawyer, you'd be getting 25 or 50 grand to deal with this. And it's just, there's a point, everyone has their limits. And I think most of us have said, we cannot professionally run something of this complexity with a 10-hour allotted prep time. So on that happy note, thank you, Mercedes. For those of you who are still with us, if you are able to turn your camera on, Mercedes, this is a age-old, time-tested tradition of we take a group photo for
Oh.
social media. But first, I have to figure out how to stop the recording.